was in this collision, do you?
Nobody does.
Tense moments during cross-examination. We take a closer look at that exchange. Plus, no rebuttal witnesses. Canton Confidential, the Karen Read murder trial starts right now. The defense says it will officially rest their case tomorrow, and now closing arguments are scheduled for Friday after a late-day ruling by Judge Beverly Cannoni. Good evening, everyone. I'm J.C. Monahan. Glenn has the night off. Melody Mendez has been following this. Melody, this is a sign we are making progress toward the end, right?
JC, we absolutely are. And I'm glad you mentioned that, because tomorrow the jurors won't be here, but we'll still be making progress even then. And here's why. So tomorrow, the judge will take time with both attorneys from both sides, and they will essentially iron out the jury instructions and the verdict forms, those very, very important documents that will go with the jury when they go into deliberations. But let's talk about the progress you mentioned that happened in court today. So Dr. Andrew Rentschler, we know he is one of the ARCA witnesses. Look, we've known for a long time how important those ARCA witnesses are to this case, not just because of the testimony that we saw them give in the first trial, but because how hard the prosecution fought to not have those ARCA witnesses be on the stand this time around. Well, they were. Dr. Andrew Rentschler was out there today, and today we really got to see why the prosecution was fighting so hard that they not testify. Take a look.
If you can't prove that the impact happened, then everything after that doesn't actually matter, does it?
Defense witness Dr. Andrew Rentschler, a biomechanical engineer from ARCA, on the stand all day, testifying there is no evidence to show a collision happened, and says there's no science to back the prosecution's theory at the very core of this case. First, talking about his own testing. When addressing the damage to John O'Keefe's clothing, he pointed out the number of abrasions on his skin not matching the number of tears in his sleeve.
You 36 different points of contact to get through the sweatshirt and get to the skin.
How many defects were noted by the crime lab in Mr. O'Keefe's right sleeve?
9 defects.
He testified about O'Keefe's injuries, the lack of any bone breaks or even minimal bruising to his arm. He says proves there's no possible way he was hit by a 6,000-pound vehicle.
So even at 10 miles an hour, you're going to have 600 to 1,200 pounds of force acting on the arm.
Is that enough to break it?
That's more than enough.
Rentschler then took aim at testing done by the prosecution's expert witness, Dr. Judson Welcher, systemically dismantling what Welcher called the blue paint test.
You can't say that the area where the blue paint is corresponds to the area of the abrasions if you don't take measurements. If you just eyeball it, all you can say is by eyeballing it, it looks approximately the same. You can't say with any scientific certainty that that area of paint corresponds to where the abrasions are.
Under cross-examination, Brennan tried Rentschler on his criticism of their expert's report, but Rentschler pushed back.
Dr. Welcher said in his report on page 9, he said, I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. If he did not recreate how he was positioned, if he did not determine the speed of impact, if he did not determine how Mr. O'Keefe's body moved, if he did not determine where he ended up, then he did not conduct either an accident reconstruction analysis or a biomechanical causation analysis. He did nothing of the sort.
Brennan leaning in.
You have no information about the angle of Mr. O'Keefe's body.
We have no information that he was even hit by the Lexus. So there wouldn't be any information on the angle if his body wasn't hit.
Rentschler doing the same.
So first of all, there's debris in the yard. What that's from, is there a collision? Was there a collision? Where did that come from? Where it was positioned? Conjecture and supposition, those aren't actual facts, sir.
At some points, clearly alluding to the defense's theory of the case.
And did you consider how that hat ended up on the ground in front of 34 Fairview?
Someone could put it there. I mean, there's a number of different possibilities.
You have a theory you want to share with us about planting evidence? Is that what we're getting at, sir?
We also learned today the judge will give each side 90 minutes for their closing arguments, JC. Hopefully that'll happen Friday.
All right, now you had a chance to speak to Karen on her way out of court. What did she have to say?
Listen, you know, Karen is usually very stoic on her way out of court. She does give the media a few minutes every day to answer some of our questions. Today, I asked her specifically, like, do you get a chance to rest? No pun intended, just to take a break, take a beat with your team. And she said, absolutely not. Now is when the hard work begins to craft their closing arguments, which are hugely important. And they need testimony to be over before they can begin doing that. She said that's how they will spend their next few days. JC.
Melody, thank you.
What do you make of the prosecution not calling any rebuttal?
It's strong. Well, that is Karen Reed also reacting to the Commonwealth's decision not to have any rebuttal witnesses in her retrial. Thankfully, joining us now to talk about it all is our chief legal analyst, Michael Coyne, criminal defense attorney, Neil Fager. Fagel, this decision to not call any rebuttal witnesses seems to be a big decision by the Commonwealth. Were either of you surprised by it?
I wasn't surprised.
Weren't?
No, JC, I think that the Commonwealth has put in a tremendous case. So the defense as well has put in a good case. And you can't, we're not in the courtroom. And when you're in a courtroom during a trial, you get a sense of the dynamics in the courtroom. I think they thought enough was enough, and it's ready to go on to closing arguments and get the case to the jury.
Did you have a feeling?
No, I was a little surprised. I never get the last word at home, so I always want the last word in court. And you always generally do want the last word on an argument. So I was a little surprised, although I'm not sure who I would have called. I don't think the dog bite expert was helpful. I'm not sure put my accident reconstruction expert on again to face some more cross-examination. I agree with Neil when he says I think the government feels that they've presented a strong case. If the jury finds their witnesses credible, they believe there's enough evidence to convict her on at least one or more of the charges.
We know that the FBI was a part of who commissioned that first reconstruction expert team, ARCA. Due to court rules, Alan Jackson can't say F during the proceedings. He kind of has to dance around it a little bit. Take a listen to this moment.
Mr. Brennan asked you a couple of questions about they being your employer. Do you remember those questions at the beginning of his cross-examination?
I do, yes.
Who is your employer? The actual employer that you work for? Okay. Wasn't them.
No,
It was a client, correct?
it was a client.
A
That's
completely
correct.
separate entity that hired you for that work, correct?
That's correct,
Thank
yes.
you.
I have a viewer question from Janet in North Reading. Just heads up, it's 3 parts. She wants to know, is that normal for the FBI to get involved? Will the jury be told that ARCA was originally hired by the FBI? And if the FBI had these from ARCA, why was Karen Reed charged? Who wants to take that first one? Is it normal for an FBI to get involved in a case?
Not normal at all, especially in a state case that's already pending. Very highly unusual.
And this time around, what was the basis for it? Do you know?
Well, the basis for it was to investigate, in essence, the investigators to make sure. And, in part, that Sandra Birchmore case that likely the feds have now charged, likely was found, at least in part, as a result of some investigation concerning this case.
Cross-pollination here.
Yeah, absolutely. And I do think what happened is the lawyers brought some of the information to the feds, asking them to investigate it further to see if there were a basis to argue that the charges were not appropriate and that the investigators had done things that were inappropriate and violating federal law.
Does the jury get to find out?
Absolutely not.
No.
It's highly prejudicial. They would never hear that.
And that's the reason they have to dance around it.
Right.
Absolutely.
And the reason Karen has to pay for both this series of witnesses and testimony, because she hired them this time, the reason she paid for them last time just for their attendance at trial and the testimony and the time they gave then is that they were no longer employed by the federal government at that point. If you wanted to bring them for the first trial, you had to pay for their time and travel.
Okay, so here's an example of when the prosecution has their expert witnesses, the defense has their expert witnesses. Our viewer Janet says, well, if the FBI had these results from ARCA, why was Karen Reed charged? That implying that what the FBI or what ARCA found is the fact.
But the FBI is not the charging entity. And the case went before a grand jury.
Right.
And the evidence was presented to the grand jury, and the grand jury determined that there was enough evidence to charge her, not the FBI. The FBI's job is only to investigate cases and develop evidence, and then bring that evidence, in the case of the FBI, likely to the U.S. Attorney's Office, And if it was a state police case, it would be to the Norfolk County District Attorney's Office.
And Reed wouldn't have been charged for the initial work, the initial report, their preparation and their findings for that. That was charged to the federal government. She would have been charged for, and what she paid for ultimately was their time in May and June when they actually came to Boston to testify both for the voir dire hearing as well as the actual trial.
Let's talk about the last witness that they did call. Dr. Rensler called as a witness by the defense during the first trial. So how do you think he did this time around compared with the first trial in terms of thinking of it from the jury's point of view? Was he easier to understand? We have the advantage of having heard it twice, but since we have, what do you think?
He was pretty easy to understand. He used illustrations that would help convey the information to the jury in a reasonable fashion. He held his own with respect to most of cross-examination. But again, the real question comes down to which series experts the jury is going to find more credible, because at times there was some hostility to the questions of the questioner. But that comes with part of the give and take between lawyers and professional witnesses as well.
Did you think he held up well?
I think they both held up well. And I think one thing that Michael and I talked about was that the defense expert, with regard to his diagrams and his video, actually helped the prosecution, where the defense expert put a video on that showed the, I'll call him the crash test dummy, was hit and then spun out and around. And that was really the case that Attorney Brennan is making and the Commonwealth is proffering.
Let's go to let's go to another viewer question while we're on the topic of ARCA. Rose from Pennsylvania, she asks, the Commonwealth was offered ARCA for the trial but refused. And this goes back to what we said before. Could the jury hear that they refused to use them?
Not likely.
Never.
Right.
Never.
Can't say we had this and they chose not to use it.
I did think one witness offered testimony to the point of, well, we would have testified for either of you, but the Commonwealth didn't want the testimony. The fact is that they don't believe that their investigation was as thorough as it can. And even today, they've testified that they were on a relatively short budget, and at least Attorney Brennan tried to elicit the idea that, well, they didn't get to run all the tests and all the information that they would have liked to have obtained.
Battle of the experts again. Running out of time for this segment, but I just want to get quickly. We're not saying the defense has officially rested. They plan to rest tomorrow. Can you just very quickly explain that semantics on that?
Yeah, once you rest, the evidence is closed. They're fighting about one small piece of evidence with respect to the PowerPoint presentation the defendant wants to use in their opening. So technically, I would say the defendant is resting. They're not quite rested yet. They'll resolve that issue in the morning with respect to this one somewhat disputed piece of evidence that Attorney Brennan is opposing, and they'll resolve that. And then the defendant will formally rest. The defendant will then move for a required finding of not guilty tomorrow.
Agreed.
Agreed?
Agreed.
Right. That's why we have you, because the facts matter. So Michael Neal, thank you for being with us, but don't go anywhere. We have much more to talk about. Our courtroom insider, Sue O'Connell, joins us next to go over a few heated moments inside the courtroom today. First, once again, as we always want to do, we want to take a moment to remember the victim in this case, John O'Keefe. Few facts. He grew up in Braintree. He served as a Boston police officer for 16 years. We've heard a lot about what a good friend and brother he was and how he became the legal guardian of his niece and nephew after they lost both of their parents to illness. He was just 46 years old. You're watching Canton Confidential, the Karen Read murder trial.
Don't miss any of the Karen Read murder trial. Get the full recap of what happened in court, expert analysis, and what we could see next. This is coverage you won't see anywhere else. Canton Confidential, weeknights at 7 on NBC 10 Boston.
He has no evidence to say the position and orientation of the arm in the lacerations, which are abrasions, are consistent with the taillight cover. That's the only test he did. So if it doesn't represent that, it's really meaningless in his analysis and conclusions.
Now that you've shared your opinions, can I get back to my question?
Sustained. So, Mr. Jackson, Mr. Brent, all right, I'm going to see counsel at sidebar.
Yes, that was one of the moments during the testimony of the final defense witness, Dr. Andrew Rensler. We're back now with Michael and Neil, and of course, our courtroom insider, Sue O'Connell. Defense attorney, you could hear him. He wasn't quite in front of a microphone, but it was Alan Jackson and Judge Cannoni to admonish Special Prosecutor Hank Brennan for the comments that he said. Thank you for your opinion. Can I get back to what I wanted to ask you? She called that sidebar. Can you read into any of that, that moment in terms of where we are, or where Hank Brennan's head is, or?
They're both at an end. We talked about this briefly.
Good morning.
The patience is gone. They're a little sick.
I don't know who's been following this trial, but
too long,
it's just been
with
so
without air
big,
conditioning at times.
too much to cover.
And so they're
But I
both
did want
pushed
to
the
get a chance to
boundaries
try to
on
cover
that
the end
at
here.
many times. And it's reason why we have had so many sidebars.
If you have
is
not
that,
already done so, please go ahead
they're
and
both gone
subscribe
beyond what her rulings are.
and hit that
and,
like button and
been
share.
inappropriate things, and she's trying to rein that in. And that was a particular acute moment where they needed to be brought back,
trial
and
has
both of
been
them needed to
really
be told to
crazy.
turn the temperature.
But they're both advocating for their clients. Attorney Brennan's client is the Commonwealth. Attorney Jackson's client is Aaron Reed. They're both doing the best they can, but I think to what you say, they're getting to the end of the
Well,
road.
but respect, civility, and
Yes.
professionalism are important. And I think over the last week or so, we've seen that line extended a little too far. And I don't know whether what you've seen as someone in the courtroom.
We're going to play a little sound of that, but because we need Sue's opinion here, the little heated moments in courtroom. Take a listen.
You have no idea where the point of impact was in this collision, do you?
Nobody.
I'm asking you, not nobody.
Yeah,
You, excuse me.
So Nick, go ahead and ask the question.
Dr. Rensler, before this jury, have no idea where the point of impact was of this collision.
that's correct. There's no evidence.
All right, Sue, you were in there.
So, one thing I want to say is that all of these lawyers, because there's a gag order, we have a lot of great conversations about diets and food and suits, and they're all warm and friendly and nice. Having said that, today there's the youngest male juror who I'm not even sure is breaking 25, sitting in the front row of the jury box right next to Hank Brennan as Hank is yelling, and he went like this, right? And then Jackson jumps up and yelled. He's just a very fidgety kid. He's doing this, and I think they are also at their last nerve in the jury box because of all the sidebars. When there's testimony, things happening, they're paying attention, but then they're like, oh, come on, you can just see it. Let's get going. So all of this arguing, which I think is a lot of lawyering, which to your point is for their clients, but it's too much lawyering. And the jury is just getting done with it. And when they're fighting with each other, they're just like, ugh.
Okay, and then Joni is playing referee.
And then she's got to tell the jury to disregard things that took place. And that's an impossible task for them to have, to just simply disregard the last couple minutes of this skirmish that occurred in front of them, or whatever the questions were
And we
asked.
think the question that the juror asked yesterday about, what's it mean when it's struck? It wasn't necessarily what the definition is, but they're confused as to what they're striking. Right?
Sure.
They just strike what he just said. Well, what part? The last word, the last sentence, last paragraph, the last hour? What do we?
So the thing is, we have all done trials, and you've sat through many trials.
Oh, no, I haven't.
JC was found innocent.
But what we understand is an ebb and a flow to a trial, and what a trial consists of, with the prosecution's job, the defense job, and it's a choreograph. It's a dance. The jury doesn't understand that. It's 18 lay people who have never been involved with the legal system, probably for the most part. And now they're getting an understanding of it, and they don't understand.
Well, it's not a good one sometimes.
Well, they see it, but they don't understand everything.
Absolutely.
And it's up to the to impart to the jury exactly what's going on, to educate the jury.
Let's go to this viewer question right here. It's from a viewer in Shrewsbury, and it says, please help us, understand the dynamic in witnessing the dueling opinions only from well-credentialed professionals or experts. It's likely that some are willing to shape their conclusions to concur with the prosecution or the defense's theories. Again, this goes back to, if they all have these stellar resumes, how do you in the delivery room say, well, we're going to take his out and we're going to take hers, or vice versa?
You got to remember, it's an opinion, right? At the end of the day, it's an opinion. Experts get to give their opinion. Most lay witnesses cannot give opinions. We don't care what they think. We do care about this group. So you've got to evaluate whether what they think at the end of the day has a solid basis in both expertise as well as science. And if so, which at the end of the day you credit to a greater extent, or decide you're going to reject both of them, and that can happen.
And one of the things today was that Attorney Brennan kept asking the ARCA expert whether or not variables existed, and that changes everything.
And that's what they're trying to bring out. So it's still a hard job for the.
But just quickly, Sue, in terms of this last witness,
Yep.
how would you assess compared to
he-
the other experts? Because
Yep.
again, dueling experts.
The ARCA guys did a great job presenting. Both witnesses did. And I will say there's a lot of male alpha in that room, as we keep seeing, a lot of measuring of things, if you know what I mean. So Dr. Russell and Dr. La Posada, they both brought a different sort of energy, and especially the young women on the jury, they were reacting very favorably to both of those witnesses. And I think that also makes them hear the expert testimony differently when they're not being yelled at.
And I think that's something to really look for as we come down to who are the 12 that are going to decide it? What's going to be the gender makeup there? Because I think that can make a huge difference. As Sue points out, 2 of the women witnesses, the doctors, could likely highly welcomed and received by the women on the jury. And some of the plaintiffs, the Commonwealth's expert, might have been seen as a little too arrogant by some. So I think the gender distribution at the end of the day on the final 12 is going to really be important to what this jury does.
But you don't know, because they're just
No
going to
idea.
exclude 6 people.
Randomly selected.
Closing arguments. Hey, Michael, Neil, Sue, thank you so much for joining us tonight. And of course, thank you for tuning in. If you have any questions about this case, keep sending them our way. The email on your screen, canton.confidential@nbcuni.com. We'll answer as many as we can. And remember to join us every weeknight at 7 on NBC 10 Boston. We'll have a full recap of the latest developments from court, as well as legal analysis. You're watching Canton Confidential, the Karen Read murder trial.
Do you think that based on your analysis, was Mr. O'Keefe thrust backwards? Is that what you determined looking at his head injury?
That he was, I didn't understand. You had your hand in front of your mouth.
Sure, I'm sorry.
Yeah.
You talked about a head injury that Mr. O'Keefe had, that
Yes.
he suffered from,
Yes.
that caused his death.
Yes.
Was that caused by being thrust backwards?
Yeah, the motion was upwards, down.
Okay. And the way you just showed it could be a fall.
Correct.
Did you have an opinion looking at his wound that he was thrust backwards?
What do you mean thrust? His body went back. There may have been some applied force to it.
I don't know about thrust. I'm asking if you have an opinion. Your words. Do you have an opinion about thrust?
What do you mean?
Did the forensic pathology diagnosis mean Mr. O'Keefe's body was thrust backward?
If you want to say thrust as indicating movement, that it went backwards, then you could say it was thrust.
May I approach?
Yes.
I'm showing you page 2 of your report, Dr. LaPosada.
Yes.
I'm just going to read it, not out loud, and then I can ask you the question if we take it, but I want to.
Yes. Yes.
Are you familiar with that?
No, absolutely.
So, Dr. LaPosada, what did you mean when you described that Mr. O'Keefe's body was thrust backward from a standing position?
I mean that he was standing upright and his body had momentum and went down and hit at the back of his head. So it was thrust backwards.
You cannot tell forensically how much momentum he had, can you?
No, we don't do those analyses.
You can't tell if anything caused that momentum based on the head injury, can you?
What do you mean causative? It was caused by his body went backwards.
Yes. So the amount of force causing him to go backwards, that's not something you can determine from the head wound, is it?
No, I can't tell you the amount of force. It was significant because he had the massive skull fractures.
Did you say it would be significant?
Yes, significant force.
In modern medicine, there are a number of different machines that can help us see the brain, like a CAT scan, perhaps,
Sure.
MRIs.
Yes.
Would you agree with modern medicine that the use of MRIs and CAT scans and other tools give a clinician equal, if not better, opportunity to examine the brain as actually cutting it and holding it in your hand?
No, the actual gold standard is the pathology, to be able to have the brain in your hand, look at it with your naked eye. And we have conferences in the hospital where we meet with radiologists and say what we find at autopsy and see if their radiology was correct.
Can CAT and MRIs show contusions on the brain?
They might.
Subdermal hemorrhages?
Subdural hemorrhages. Yes, they can.
Herniations?
They can.
Do you have any doubt about the modern medicine use of MRIs and CAT scans? Do you think they're inadequate in any way?
Well, I'm not a clinician, so I don't use those to diagnose diseases in living patients.
Dr. LaPosada, have you ever had any experience studying the brain in real time, clinically, going and opening somebody's skull and treating the injury before the person dies?
No, I'm not a neurosurgeon.
You don't have any neurological expertise, do you?
I'm not a neurologist. I'm not a neurosurgeon. I'm a forensic pathologist.
Do you have any clinical experience at all? There's an acute head injury and you're making an effort to observe it and analyze the injury as it progresses in an attempt to save the person's life.
I don't treat or diagnose living patients.
I understand, but as far as your background, have you ever had any experience, clinical experience, showing the progress of an actual brain injury and trying to treat it?
I understand the physiology happens to the brain when it is impacted by something, whether it be a bullet, a boulder, a fall. So I know what happens to the body to cause the changes from that trauma. I don't treat people for those injuries.
In observing a brain that's in trauma and making determinations of how long it's viable or the person will expire, do you know the process that a neurosurgeon would go through in order to fight to preserve the person or save the person? Do you know the step-by-step process that they would undertake
Do what?
to try to operate or save somebody from a head injury, from a brain injury?
I'm going to allow it because of prior testimony.
Well, it depends on what the brain injury is. If you have head injury and you have bleeding on the brain that's pushing the brain one way or the other, it would be a subdural. Then a neurosurgeon would come in and try to take that blood away. It doesn't compress the brain. So that's something that neurosurgeons do to treat head trauma. They can also put in drains into the ventricle of the brain, and that can relieve pressure in the brain because brain swelling is a bad thing. So those are some of the things neurosurgeons do to treat brain injuries.
Can they remove part of the skull to relieve pressure?
Oh, yes, they can do that. It's called a craniotomy. They can take out part of the skull if they need to.
So there are a number of different steps that a neurosurgeon can take when someone suffers acute brain trauma to try to save the person, isn't there?
Well, the job of any doctor is to try to save a human life if you treat living patients. So certainly a neurosurgeon would evaluate the patient and decide if there's any treatment needed that could improve the patient.
When you've had in the past as a medical examiner where there have been issues regarding brain injury, wouldn't you agree that you have sought outside consultation with people who have a higher degree of specialty in brain injury than you?
Sometimes what we do is when we're examining the brain, we can call in for a conference and have a neuropathologist come in and review the brain with us.
On for trial. If the parties could please identify themselves for the record.
Good morning, Ms. McLaughlin. Good morning, Mr. Lally.
Good morning, Your Honor. Thank you for the Commonwealth.
Good morning, Mr. Brennan.
Morning, Your Honor. Robert Alessi, Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti from Karen Reed.
Good morning, Mr. Yannetti, and good morning, Ms. Reed. All right, so Mr. Yannetti and Mr. Alessi, you're standing in also for Mr. Jackson and Ms. Little?
We are.
Okay. All right, so first thing we left off yesterday was whether KKKK for identification, the PowerPoint of Dr. Rentschler would be entered into evidence. It will not be based on the objection, so it is excluded from evidence. So it's marked still for identification and your rights are saved on that. So we ready to go forward with the charge conference?
Yes, Your Honor. I guess I have a question first as to whether the court would like to entertain the argument on the motion for required finding not guilty of all the evidence.
So no, we can do that now. So now that my ruling is on this, evidence is closed as it was yesterday. So go ahead on your required finding argument. Sure.
And this is not lengthy, Judge, 5 or 10 minutes.
Take your time.
Thank you. We are renewing our motion for required finding of not guilty at the close of all the evidence. And in so doing, Your Honor, we're incorporating our oral argument in support of this motion that we made at the close of the Commonwealth case. At that juncture, Your Honor, the Commonwealth had produced no witnesses to testify that John O'Keefe's injuries were consistent with his being hit by a motor vehicle. And if he was not hit by a motor vehicle, none of these three indictments may stand. The Commonwealth, we believe, at that time fell woefully short of proving their case. Now that the defense has put on a case, the Commonwealth has been further weakened.
Yep.
Such that none of these charges can stand. Nearly every witness, Your Honor, we have called, we would submit, has destroyed the Commonwealth's theory of the case. Dr. Russell testified for the defense. She's a leading expert on dog bite wound pattern recognition in the country, and she testified about medical injury causation and provided the jury with her expert opinion that John O'Keefe's injuries were consistent with inflicted wounds, both bites and scratches. I would remind the court at this juncture that there was a dog at the very residence where John O'Keefe was found. a dog which was a longtime member of the family, which the family gave away after John O'Keefe's death. A dog which mysteriously was absent from the home at 6:30 in the morning on January 29th, when Jennifer McCabe claimed that she burst into Brian Albert's bedroom where the dog always slept. A dog which was absent from the home when the police entered the home later that morning. Importantly, Dr. Russell agreed with the Commonwealth's medical examiner, Dr. Scorti-Bello, that John O'Keefe suffered no injuries that were consistent with having been in a motor vehicle collision. If there's no collision, there's no case. Dr. Loposada, one of the most experienced and accomplished forensic pathologists you could find anywhere, agreed with Dr. Russell that John O'Keefe's injuries were consistent with an animal attack. She agreed with both Dr. Russell and the Commonwealth's expert, Dr. Scorti-Bello, that John O'Keefe was not hit by a motor vehicle. So the question is, in what type of murder case would a judge ever allow a motion for required finding of not guilty? In a murder case where expert testimony on both sides is that the evidence is inconsistent completely with the Commonwealth's theory of the case, that's exactly what we have here. But it doesn't stop there. Both witnesses from ARCA drove a stake through the heart of the Commonwealth's case. Dr. Wolf concluded that the damage to Ms. Reed's Lexus was inconsistent with having come from a collision with John O'Keefe. Unlike Dr. Welcher, who created, we would submit, a meaningless experiment based on no scientific method, Dr. Welcher actually did the proper force analysis and concluded that Ms. Reed's Lexus was not damaged by the body or the arm of John O'Keefe. His testimony was unimpacted by cross-examination, and it's devastating to the Commonwealth's case. Dr. Rentschler further cemented that there was no collision between Lexus and John O'Keefe. It is simply not possible that this 6,000-pound SUV hit John O'Keefe at 24 miles an hour and caused only superficial wounds to his right arm with no injuries to his legs or lower body. The SUV did not hit him. John O'Keefe was not hit by the SUV. The case is over. But on top of all that scientific evidence, Your Honor, there were 3 additional fact witnesses who testified for the defense who corroborated that Commonwealth's theory of the case is false. Sergeant Nicholas Barros, a sworn police officer, testified that when he saw Ms. Reed's SUV that day, before it was towed to the Canton Police Sally Port, the taillight was merely cracked. When he was photos of what it looked like in the Sally Port after Michael Proctor had access to it, Sergeant Barros confirmed that it was absolutely different. Karina Kolakithis confirmed that there were no problems between Karen and John O'Keefe that night, remarking on just how sweet he kissed her on the forehead shortly before they left the waterfall. But perhaps more importantly, that kiss happened right in front of Brian Higgins, the same Brian Higgins who had been flirting with Karen Reed that night, the same Brian Higgins whom Karen had ghosted for several days before January 28th, the same Brian Higgins who had texted Karen that very night, well, and received no response, the same Brian Higgins whom Karen are back to all night, the same Brian Higgins who had to be restrained at the end of the night by Chris Albert on video,
I think
the same Brian Albert who is on video, hot, angry. I meant Higgins, yes. Yeah, the same Brian Higgins, who is on video, hot, angry, and gesturing to John O'Keefe to meet him outside shortly before they left the waterfall and shortly before John O'Keefe was killed. And finally, Brian Loughran, plowing Fairview Road at 2:45 in the morning, was attentive, watching everything in front of him, very familiar with the Alberts residence, and had every reason to protect the Albert family. You recall that he did protect the Albert family to a degree that night by choosing not to follow protocol and call the DPW or the police about the Ford Edge parked on the street outside their property during a snow emergency. Brian Loughran confirmed that John O'Keefe was not on the front lawn at the Albert residence at 2:45 a.m. That means that Karen did not hit him. There was no collision. All the experts agree on that, including the Commonwealth's expert, and the only eyewitness that morning confirms it. The evidence in the light most favorable to the Commonwealth at this juncture, with their evidence weakened by an airtight defense to these charges, these indictments cannot stand, and we urge this court to enter required findings of guilty on all 3 indictments.
Thank you, Your Honor. Commonwealth requests that the defendant's motion for required finding not guilty at this juncture, as it was at the close of the Commonwealth's case, be denied. The state of the evidence is not dramatically changed since the Commonwealth rested its case in chief. Counsel makes reference to
This
dog.
is the attorney
canine.
that did the first trial.
Remind the court that there is absolutely no evidence, none, not even a scintilla of evidence of a dog. There is no evidence of an absence of a dog. You have Ms. McCabe testifying that she didn't see it in the morning, which does not equate to there being an absence of a dog there.
She saw it.
Arguments from counsel of the Commonwealth would suggestfully exaggerate the strength of the defense witnesses in their case. The bias and advocacy exhibited by those witnesses from that witness stand do not amount to credible witness testimony that undermine the Commonwealth in any way, shape, or form. A couple of specific examples when it came to Officer Barros. His testimony was also that the cruiser camera footage from 8:22 in the morning at the driveway at One Meadows Ave, he indicated the damage to the tank was consistent with the damage that he observed in the driveway at the defendant's parents' home, which was then consistent from the video or the photographs within the Sally Port. It's also consistent with 5:07 a.m. at One Meadows Ave on the still shots from that Ring camera video. Essentially, the Commonwealth would submit that the defense witnesses all conflict with each other. You have a couple witnesses testifying about dog or animal bites. Then you have the ARCA witnesses testifying about superficial abrasions. You have Dr. La Posada talking about the drop in body temperature, which conflicts with Mr. Loughran's testimony as far as his confusion, as far as the hours of when he sees or claims to have driven by and not seen a body. This is the same witness who is, I would submit, very confused on times, and then also backed into a basketball hoop during the course of his plow duties on that particular early morning as well. And as the court could see from the cruiser video, drove by the scene countless times, essentially rubbernecking it as he's going past doing his duties. Your Honor, what the Commonwealth would submit is that his case was more than sufficiently strong at the close of the evidence in his case in chief. There has been nothing presented in the defendant's case to diminish, particularly to the standards in the light most favorable to the Commonwealth, and we request that the defendant's motion be denied.
So, Mr. Yannetti, you know I have to see the light most favorable.
I do, Your Honor.
And viewing it that way has met its burden, so the motion's denied. Okay?
They have not met their burden.
All right. So regarding the
Ain't proved nothing.
So we'll start with the.
Committee was gonna deny it.
defense Missing witness request. Who's arguing that motion?
We're not arguing that, Your Honor. And I apologize, but we made the decision to withdraw 2 of our requested instructions to shorten things today. I think it's,
Oh, okay. So everything on this is done, right? The defendant's motion to present a missing witness argument and request for instruction. You're withdrawing that?
With regard to the absent witness instruction, we're withdrawing that.
Okay. And what else from your proposed instructions? You said there were 2. What's the second one?
The second one is that there's an entry on our request for loss or destroyed evidence where we're withdrawing that.
Okay, I had a question about that. All right. Thank you.
There is a supplemental instruction that we're asking the court to give regarding the display of this sweatshirt.
Oh, that's right. You filed, I saw it in email. I don't have a hard copy of it.
That's Mr. Molesky's motion.
Your Honor, if it's helpful to Your Honor, I'll hand up my hard copy.
Okay, if you could do that, I'd like to go back through the rest of it and come back to that after I've read it, okay? Who's arguing for the rest of the defendant's proposed instructions?
I am, Your Honor.
Okay, so we're gonna go through them one at a time. Who's arguing for the Commonwealth? Okay, so I think you're sort of meant on the basis of the law, right? All right, so model homicide instructions, just as last time. So that takes a lot of time out of today.
The only thing I would draw the court's attention, the Commonwealth does have requests for, and I understand, of course, Commission might be on this, but as far as the instruction related to murder charge, Commonwealth is only seeking instruction on murder problem.
All right, so we will deal with that. I'm going to go through the defendant's instructions or sort of the general instructions first, so it's probably easier to go through those, and then we'll have the argument on that. So presumption of innocence, I think my presumption of innocence is a little more robust than what you've requested, so I will probably, okay. And I will give some version. I know that there was a lot of attention paid and some appellations on the each individual indictment. I'll give some further language on that. You've got an instruction and proposed on page 4, reaching a verdict. Just will make it crystal clear, though. I think it was, and I was upheld on it. So I will make it crystal clear. Okay. So I'll give you that, Ms. Giannetti. This what is evidence. I probably won't give verbatim what you have. I'll take a look at it, but I will certainly cover all these topics. So Ms. Giannetti, you're telling me that your client wants me to give a defendant did not testify instruction?
Yes, please, Ron.
Again, if you take a look at what I gave last year, I think it's a little more robust than this.
I think we answered satisfied with the court's instructions on that, so we would be satisfied again with the court's language.
Okay. Humane practice, I will give you Bowdoin. I'm going to take a look, size this up with what I gave last year. I gave Bowdoin last year. I gave a Bowdoin instruction. I don't think the Commonwealth objects, right? Okay. Go ahead. Do you want to make an argument?
Just briefly, Your Honor, when it comes to the Bowdoin, and I would incorporate, and I know there's no request for instruction for third-party culprit, but the Commonwealth would be making similar requests that counsel be prohibited from making a third-party culprit or Bowdoin argument.
Or Bowdoin? Or Bowdoin? You don't think the Commonwealth, the defense should be to make a Bowdoin to argue Bowdoin?
So I would submit, Your Honor, that the entirety of any testimony or evidence related to either Bowdoin or third-party culprit in this trial has come from defense, not from actual evidence in the case, not from testimony from witnesses from the stand, exhibits that have been put into evidence, or anything like. So in the instruction and arguments are based or predicated based on evidence. Obviously, as you're well aware, there's a specific instruction that no matter how powerful they are, questions to counsel are not evidence. So what the Commonwealth would submit is if the court looks at what is actually in evidence in this case, there is no basis whatsoever for not only Bowdoin or third-party culprit instruction, but specifically for even counsel to make that argument during the course of the vote. And I understand Bowdoin is a little bit more loose as far as the court certainly.
So I'm going to ask Ms. Giannetti to explain to me. All right, so I disagree with you on Bowdoin, but I'll take a closer look at it. Ms. Giannetti, what is Bowdoin evidence that warrants an instruction?
I think it's multifaceted, Your Honor. The police did not secure the crime scene properly. They used inadequate materials to pack the evidence. Chastity was contaminated and corrupted. There was evidence of the bias, the investigator failure to pursue the suspects, specifically telling his friends that the homeowner was saying because he's a Boston cop too. There was just a focus on Ms. Reed to the exclusion of everybody else. It was not an open-ended investigation. From day one, it was focused on one person and one person only. And just responding briefly to Mr. Lowry's comments about how he didn't introduce affirmative evidence of the proper way to do an investigation. We tried, Your Honor, we made a motion and renewed it, asking for reconsideration of the court's ruling that Mike Easter could not testify about an investigation. So to say that we didn't introduce that evidence when we tried to do it, we were
I think what Mr. Lally was saying, that you asked questions but weren't given answers. And so I think that's what was said. I'm going to, Mr. Yannetti, I'm going to allow you to argue Bowden, and I am going to give an instruction. So third party is an entirely different animal here. I know. But tell me, are you going to argue it? Is the defense going to argue that Brian Higgins did this?
No, we're going to argue that the police failed to investigate whether Brian Higgins did it.
Okay, so just so that it's clear, that you all know, I believe, third-party culprit separately is a lot different than third-party culprit as it goes to Bowden. I told pre-trial that there could be no attempt at introducing third-party culprit evidence regarding Colin Albert. So that was separate. But I did say that I would give you the opportunity to try and develop testimony regarding Brian Higgins and Brian Albert as third-party culprits. That threshold that you need to make to do that, to argue them as three-party culprits, has not been made by the judge. So you cannot argue that either Brian Higgins or Brian Albert committed or had the motive and all of that. Not third-party culprit, pure third-party culprit. You understand that? It sounds like you're telling me you don't intend to do that.
We have the distinction you are, and we're strictly going with a Bowden defense.
Okay, so you can get into third-party culprit with Brian Higgins, that the police were aware of where you're going to argue and failed to act on it. But it's strictly for that purpose, okay? Okay.
And that's really what I was seeking, this clarification.
Yeah. So Yannetti, and of course I take him at his word, tells me that they're not going to do pure third-party culprit. Okay, that's great. That makes that easier. So I will give, sure, go ahead.
While we're on page 8, I just wanted to almost let's have that's at the top of page 8.
Yeah, I have a check mark next to that. Ms. Yannetti, tell me about this, the absence of a recording. Are you saying that the police should have recorded Mead at her parents' house?
Right. So, obviously it's not the strongest DG Batista argument that we would have did not occur at a police station, but, these days, Your Honor, it's common knowledge that everybody has access to a recorder, even on their own cell phone. It could have been done. It wasn't done. We had to rely on police memory of what my client said or didn't say when there was a possibility for a recording. So we were entitled to.
Do you think it was custodial interrogation? Or I guess I should say, do you think the evidence supports?
I think there's an argument that it was a custodial interrogation. Police officers who, refused to sit down in the living room, they were surrounded with her. Someone who was not familiar with dealing with the police at all. So yes, I think there's an argument that it's considered custodial.
All right, what do you say about all this, Mr.
And
Allen?
if I would also add, Your Honor,
Sure.
they did seize her vehicle at around the same time. So, that it goes to the issue of custody and being able to deny.
All right. What do you say?
That's the very nature of the objection, Your Honor, is the non-custodial nature of this. So the trooper spoke to basically at her parents' house, as with a number of different witnesses on that day as well. So of course of that, they spoke to her while she was seated on the couch in her parents' living room. The parents were present, no one was restricted from eating. And it did not end in any custodial situation. She was taken into custody, she was arrested. Yes, they did seize her cell phone and her vehicle based on information that they developed from the course of the day, from statements from Ms. Reed herself. But I don't think that it transforms that conversation or interview in her parents' living room into a custodial interrogation. The bigger issue that I have placement, as far as there's already been within the same requested jury instructions or requested manual practice, and then following the DAG and Batista language in the defendant's request for jury instructions, there goes on to all of this other requests regarding her compromised mental state and all of these other things that, while if it were to be given by the court, should be given in the same context of the practice. I don't think it's something that should be highlighted in two different sections. I would submit that there is no evidence of her having a compromised mental state or anything to that effect. She exercised her judgment as far as when she was speaking with Sergeant Lieutenant and have this as one from the stand, that initially she said she wanted to be fine with answering questions, but they wanted any details. And then when the questions became centered on details, at that point, and I know that's not evidence to the jury, but of course, where she then ended the questioning at that point. So I don't think there's any evidence of her having a compromised mental state during the course of this interview. I don't think that arises to the level of the instruction. So I would ask basically that everything on page 8 prior to the instruction be excised.
All right. Another look at this, and I'll just let you know in the morning.
And Your Honor, with regard to the compromised mental state, we agree that that would not apply to the interview at your residence. But we believe that it applies in the humane practice context.
That is where it makes sense. So, all right.
If it's going to happen, it should happen once, not.
Yeah.
I think that's fair.
Okay. Okay. All right. Prior statements, I will give some instruction on prior inconsistent, and I'll give a prior consistent statement. I'll talk about the view. The absent witness instruction is withdrawn. So is the,
Not to interrupt.
that's okay. That's okay.
With regard to the view, Your Honor, we did include a language reinforcing the fact that the rock we saw on the view was not present on January 29th. We asked the court to repeat that one sentence.
Okay. So I did not see this when I took a quick look at the view. All right. I'm not going to repeat it. All right. Lost or destroyed evidence you're withdrawing. Direct and indirect evidence. I'm going to try and give a shorter instruction on that. So I will, even the one I gave is too long. I'm trying to cut down the time the jury needs to hear general instructions that I think they're perfectly capable of hearing in a shorter period of time. All right, thank you. Credibility, the same. Law enforcement witness, I think I gave some instruction on that. I'll include that somewhere in it.
If I might just reference that.
Sure.
Language in there, I would object to it.
Okay.
That's what the police officer or someone else would want.
Oh, what do you mean by that?
I think that was taken into account for the dispatcher, perhaps. We're not.
The police officer, because they're police testimony, I'm not going to go beyond that. Okay, thank you. I'll do the photographs, the opinion testimony. Note that I'm giving exactly this, but I will give, I'll cover all those topics. What page you on? Okay.
One suggestion there was indicates home office introduced evidence. I would submit.
Yeah, I'm just going to say there are photographs that are in evidence. Was that the nature of your objection?
I actually think that Francis introduced more graphic.
Yeah, so I would just say you've seen photographs or photographs and evidence. I instructed twice anyway, maybe 3 times on it. So I'll give some version of that. Juror notes, I'll give some version. The implicit bias instruction, I'm going to give exactly what the SJC told me I should give. All right, so the Commonwealth's requests are sort of in the, you start with the law and then you get into the general instructions, Mr. Lally. So let's skip to your, it's not numbered, your supplemental instructions, use of a dangerous weapon. All right, so I'm going to give that, Ms. Giannetti. I gave a dangerous weapon instruction last year on the motor vehicle.
Understood.
All right, so I'll give probably what I gave last year, and this looks like it's it. What is not evidence, evaluating, I'm going to give what is not evidence. Evaluating the evidence, there's some instruction. Ms. Giannetti, what do you think about the short instruction on jurors? It sort of makes sense to me after such a long trial. No juror is better qualified to determine the truth of the facts in controversy or to deliberate upon it than any other juror, or solely because of that, solely because of that juror's occupation, education, experience, or any other characteristic. Okay. Thank you. Charts and summaries, I'll talk a little about chalks. And inferences, I will give some. I'll give the redacted exhibits instruction. Witness preparation for trial. Do you both want this? There was testimony on both sides. It's simple. There was testimony at trial that the attorneys, and I may say if you find or something, preface it. Witnesses when, the attorneys interviewed witnesses when preparing for and during the course of the trial.
No objection.
You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the attorneys are obligated to prepare their case as thoroughly as possible and may witnesses. I don't know if there's a sequestration order, if this is appropriate though, where it says during trial, during the course of the trial. I'll just say when preparing for trial.
Yeah, we're joining in. I don't know if we did that in our instructions, but we're joining in the Commonwealth Plus for that instruction.
All right. The limiting instructions I gave, I need to just do this again here. So electronic communications, I have that on my list. The emotional impact photos, humane practice. We'll get back to consciousness of guilt in a minute. I'm also going to give the prior bad acts instruction. I did that in regard to the Aruba incident, if you want to call it that. I gave a prior bad acts instruction before that testimony came in. I also gave the instruction that I will also give on the state of mind of John O'Keefe as to his state of mind being known by the defendant and the likelihood that she would act on it. So Commonwealth versus Binns in those cases.
Your Honor, with regard to Aruba, we don't believe that there was really any testimony that came in.
I thought it came in through Kaylee. I should say it did come in through Kaylee. That's when I gave the prior bad acts instruction. She testified. Okay. All right. So did I give it any other time that there's another event that I should highlight? I don't think so.
I don't think there was an instruction of that one.
All right. I think I have to add that here. So, all right. And I will look at it and decide whether I need to add it specifically. It might be covered enough. Might be covered enough when I give the electronic communications instruction. So I will think about that. All right. Those were the limiting instructions I wanted to get to. So
We would object to the prior bad acts being linked to the Higgins text message.
all right, I'm going to take a look at that, Mr. Lessie. All right. Consciousness of guilt. Okay. All right. All right. So tell me where the difference is in what I gave last year from the model homicide instruction on second-degree murder and where you're saying I should not this year, Mr. Lally.
No, so the only,
1 second, let me just pull that up. Okay.
Your Honor, Collins' request is merely not for any change or alteration in the instructions that were given, other than there are 3 prong of malice. And essentially, the Commonwealth is requesting is that the jury be instructed
Speak up.
merely on third prong malice, as that's the only one that really applies to these factors.
Okay.
The Commonwealth here, the first two prongs are essentially strangers in this situation, and next we'll take them here. Avoid confusion.
Do you have supportive case law for me to single this out? What do you say, Ms. Giannetti?
I mean, Mr. Brennan essentially stated that in his opening statement.
Stated what?
Well, in his opening statement, he stated that he's not alleging that she intended to do him grievous bodily harm, not intent to kill him. And it was just the third prong. He stated that in his opening. I imagine that's what he'll likely argue in his closing. You know, I don't have a position on this. I just don't know, and I think the court's going through this analysis in your head as well, whether it's permissible or not. I just raised that as an issue, but I don't have strong feelings about it.
I could say the parties agree that the first prong and the second prong are not applicable here.
I think we're just at a position where we'll refer to the court.
Well, I'm not going to say you agree if there's no agreement. If you can get me a case by this afternoon,
I will endeavor to do so, Your Honor. We will. I don't have it.
I'm inclined to go with the model. I'll see if there's something I can find. You're probably better at finding it than I am, Mr. Lally, but I'll see if there's something I can find to support the position that it's just the third prong, and therefore I only have to give that instruction. I don't think I'll find anything, but let me see. Because I can understand why both of you don't want it. Just let the jury focus on what they need to focus on.
That's really the only reason. I understand, and I don't.
You know, I suppose I could always tell the jurors that the Supreme Judicial Court has come out with jury instructions that I must give in their entire format. And that sort of explains why I say something that doesn't apply, maybe. Maybe I'll do that, but let me see if I can find something. If I can find something that says I don't have to give those first two prongs, I'll let you know before you begin. All right.
And Your Honor, before the court makes a decision on that, we see what the court is proposing if you are going to alter the model.
If I alter it, it means I remove those two. That's all.
But no, we just want.
Yeah, sure. My guess is that won't happen, but we can see. All right. So lesser included offenses. Did you want to know UI instruction? You were.
We're asking for that.
Okay. All right. Right, I think that's it, aside from Mr. Alessi's motion regarding the exhibit. Right, is there anything else that we're missing?
Just a couple of other issues. One is with regard to the Proctor text messages, we have a redacted version now, which we'd like to submit to the court of the Commonwealth. You recall that we had agreed essentially on a redaction subject to the court's ruling.
Okay.
But it wasn't in final form. We believe it's in final form now.
And you all agree that it's in final form?
Well, they haven't seen it.
Oh.
But I'm going to give it to them now. Can I hand this to the court?
Sure, thank you. All right, so
The only other issue, Your Honor, is we do have a.
hold on one second on this issue still. So I will give the Commonwealth this afternoon
to take a look at this. And tomorrow morning, if you don't have agreement, then we'll have to deal with it. And I'd prefer not to have to deal with it. So,
I'm sure we can be in touch this afternoon. I do not believe there's going to be any problem.
okay.
Just a couple other things before we get to Mr. Valesky.
Yeah.
One is that we do have the Dr. Wolf PowerPoint to be introduced to the evidence on.
Dr. Wolf or Dr. Rentschler?
Dr. Wolf.
All right. And this was allowed into evidence unobjected to. I thought we already had it. We didn't.
We have to redact it, so these
Okay.
are redacted. It's on drive.
Okay. And the Commonwealth has seen it? All right. So they'll have to see it. So Mr. Blally, Mr. Brennan, Ms. McLaughlin, one of you has to take a look at it.
And then will the court allow more than an hour?
I'll allow more than an hour. I'll allow an hour and 15 minutes. All right.
And I think I did mention that we had a proposed verdict slip for count two, Your Honor. If I didn't.
You did not.
Okay. We do have one. We've got given a copy to the Commonwealth. Can I hand the
Okay.
proposed copy to the court?
Sure. Is it the same as last year's, but now with a?
It's different.
Okay. All right.
You'll have a chance to digest that.
Oh, I digested it, Mr. Alessi. Go ahead. I'll hear you.
I'm actually an
Yannetti, jeez, I'm sorry.
So, Your Honor, you'll recall we had some spirited argument both before and after trial regarding this particular issue. And our concern, Your Honor, was that it's obviously a confusing indictment because of the number of lesser includeds and the number of elements that are different for each lesser included. And we were uncomfortable with, there being one option for not guilty at the top of the form, and then multiple options for multiple different types of guilty verdicts throughout the remainder of the form. So what we have done is to fashion this in a way where the jury, pursuant to the court's instructions, would first decide the offense as charged, and if it's a guilty verdict,
Madam Clerk?
the analysis is over. If it's a not guilty verdict, they go on to the next lesser included offense, and again, same analysis applies. If it's not guilty, they then go to the next until they finally reach the final verdict, which the lessest, or the least, I should say, of the lesser included offenses is simple operating under the influence, where they have an option for not guilty or guilty. We've also changed a little bit of the wording, you'll see, which I think makes it clearer and less confusing. When the jury is given options for theories of guilt on at least like three of the charges, including the main charge, because there's this issue of either under the influence or 0.08 or greater. The way it originally read, Your Honor, manslaughter while operating a motor vehicle under the influence of alcohol was repeated twice. It was repeated once where there's an option for guilty, and then it was repeated again with both of the other options. We think that this is simpler, it's cleaner, it's clear, and we believe that this verdict slip is the most appropriate one.
Mr. Lally?
Your Honor, as the court is probably well aware, the Commonwealth is not requesting any lesser included, and I certainly understand that if the evidence supports it, the defense requests it, that the court must give it. Having said that, the verdict slip was used in this matter last year. The Commonwealth submitted is more than sufficient and adapted to the defendant's request. The only other thing I would bring to the court's attention, I don't know if you're aware, there was a case recently, while this case was going on, tried before Judge Lau, in which he had similar issues. I believe used at least part of the verdict slip from the first trial, in this case, as sort of a template for the lesser included that he instructed and the verdict slip that they utilized in action. I don't have a copy of it on me, but I can certainly get the court somewhat helpful, of course.
Okay, was that on murder case?
It was not, but it had to do with a felony motive homicide.
Yeah, I'll take a look at it.
Mr. Turk.
Mr. Turk. Mr. Yannetti, I don't believe I'm going to give this, but I'll take a closer look at it.
Well, we appreciate that. Judge Wells is an excellent judge. We think that this verdict slip is, it provides the most clarity for the jury. That's why we're.
Okay, and that's where I think we disagree. So I will take a closer look at that. And so has it been filed officially and docketed?
I just handed it, I believe.
All right, so Madam Clerk, you have a copy up there?
The proposed, I think this is the only copy.
Okay, that's what I was wondering. Okay,
Do you need an extra copy?
sure. Yes. Or, you know what, just mark it for identification, Margaret. We'll do that. Chrissy, please. Just for ID.
It's LLLL for ID.
Thank you. Mr. Lally.
Your Honor, just one request circling back to the constitutional field instructions. So Commonwealth is withdrawing its request for the instruction.
Okay.
However, would be seeking to make some argument or reference in this argument from the jury related to specific areas which we would need judicial approval before we did this. So the two areas that are sort of listed within that, that we would like to make some argument to the jury regarding is the defendant's taking of the Lexus from one metal that came to her parents' residence in Dayton, and then certain statements made in reference to the various clips that were played of her statements.
Okay.
In particular, would be the one where essentially she says that it never came to her.
Okay.
Whatever the exact.
All right. Mr. Yannetti, do you want to weigh in on that?
Yes, we do. To that, I don't see it's her or me being evidence of consciousness of guilt. And the notion that she's driving from one residence that the police know of to another residence that the police know of, which is her parents' house. The car is open and obvious in the driveway. In fact, when the police call, she says, yes, come on over. I don't see that as being any evidence of consciousness of guilt.
Okay, so I'm going to allow them because they're permissible inferences from what's in evidence, but I'm not going to give, even before it was withdrawn, I wasn't going to give a consciousness of guilt on those.
And just to be further clear, there may be other clips.
Yes, so I did want to ask you though, Mr. Yannetti, I think it's an argument that can certainly be made by the Commonwealth regarding the video clips that your client gave during various interviews. I think consciousness of guilt is a permissible inference from some of those. Are you sure you don't want me to give the consciousness of guilt because it's got helpful language for a defendant in it as well? Okay. Okay, I just wanted to give you the opportunity. Okay. All right, anything else? Anything else, Mr. Yannetti? We're going to hear from Mr. Alessi, but
The Commonwealth does not object to the reductions.
that's great. Thank you. One less thing you all have to do today, okay? I know. All right, so let's make that, are we switching that new redacted version with an exhibit number? Do we know what it was before? Excuse me. The redactions on the Higgins messages, that's what you're saying you're fine with, right?
Proctor Communications.
Proctor Communications, okay.
Right, this is the testimony that came in.
Of Proctor, I was, yes. All right, so we'll find the exhibit number and we'll just. 209, is everybody in agreement that it's exhibit 209?
Yes, sir.
Okay.
Does the court have a copy or do they need the Commonwealth?
No, I wrote on it. I need the Commonwealths.
So this is a clean copy.
So that will now be 209 in evidence. You know what? Can we make that 209A? We need, Ms. Gianetti, we need to keep record of the first one that was not redacted. So any objection to making this 209A?
No objection to that. And so original 209 will not be sent in. Is that?
It becomes.
What do you think? Yeah. Yeah, so we'll switch it back to ID and this will just be 209. All right, did we have an ID number on it originally? Can it still be that?
Is it redacted, the NNN? Or is it, no, it can stay that.
Okay.
Right? 'Cause this is the-
Oh, it's just NNN, it's not,
Well, where did it?
no, it became 209.
So that
Our thinking is it needs to be sent back to letters for ID.
Yeah.
So it'll be marked MM for ID.
That's great.
Perfect. And then the redacted version will now just.
209.
Yes.
Yep.
And we'll hear from you this afternoon. Just somebody send us an email to the clerk's office. So someone send an email to the clerk's office today letting us know if the Wolf PowerPoint is ready to be put into evidence after the Commonwealth looks at it. Okay, so we'll take care of that. All right, Mr. Lessie, I'll hear you.
Thank you, Your Honor. If I might suggest respectfully a procedure to the court, I have spoken with the Commonwealth about what the topic is. It's obviously not new to anyone, but perhaps to expedite this matter, if I might suggest to Your Honor to avoid a more lengthier argument, it might even truncate it down to 30 seconds. If we could hear from the Commonwealth on what we have requested, and the topic specifically is entitled Defendant's Motion for Curative Instruction regarding Exhibit 88 and Introduction into Evidence of Exhibits. The exhibits is taken care of, that's no longer an issue. But I did speak with Mr. Lally, and if I could suggest that Mr. Lally can state his position as I understand it, and then I can go from there, and it may not be necessary for me to continue on.
All right. What's the Commonwealth's position?
So Your Honor, Commonwealth's position is ultimately for the court as far as whether or not it's appropriate instruction to give in the final charge. What Commonwealth will submit is that the contemporaneous instruction was more than sufficient to address the issue, and that it doesn't require any sort of differing language or further instruction given to the jury during the court's final part.
All right, I'll hear you, Mr.
Thank you, Your
Alessi.
Honor. May I go to the podium?
Yes.
Thank you. Your Honor, I have given, and Your Honor has provided me previously with a generous opportunity to be heard on this, but I do need to cover some points with regard to the matter. I was hoping to avoid doing this, but given what we just heard, it needs to be done respectfully. As Your Honor knows, we have submitted this motion, and as part of the motion, it really consists of two parts. The first part is the text and the basis for what we're requesting. I'll come to that in a moment. And then attached to it are this Exhibit A and Exhibit B, and those exhibits are our best effort at transcribing, because there's not an official transcript at this point of exactly what happened. Why do we put in the exhibits? We put in the exhibits because we believe it really sets forth and illuminates quite vividly what occurred. It occurred rather rapidly, but I think this allows for a much more these exhibits allow for a much more reflective analysis. So just briefly, what, as we know, happened is Attorney Brennan took Exhibit 88 encased in whatever the plexiglass material, had it set up, and we understand this now in retrospect, behind the witness stand. And then at a certain time in the cross-examination of our witness, Dr. Wolf, confronted Dr. Wolf with it as part of an accident reconstructionist cross-examination and challenging Dr. Wolf on several aspects. And this one was particularly apt, the subject matter, not the manner of the examination, was, Dr. Wolf, you're saying this, these are your theories. However, did you consider and take into account the holes in the back of the hoodie? And that led to a series of questions and a series of answers. And I want to go right to the end, because I think going right to the end better elucidates what actually occurred and the depth of the issue and the problem here in this misconduct, which we believe was intentional. Specifically, the end is, we know, and I believe it is completely undisputed, that the holes in each and every hole in the back of the hoodie was caused by the criminalist, a witness in this case, Ms. Hartnett, who made those cuts as part of her analysis. And that was in May of 2023, long after the alleged incident of January 29, 2022. So that's sort of the end, undisputed. Now let's go back to what happened in the examination, the cross-examination of Dr. Wolf. So he's confronted, and I think, we put in Exhibit A and B of it, but what is particularly striking is on page 7 of Exhibit A, and it's the colloquy that starts in the middle, which we've yellow highlighting, Attorney Brennan saying, when you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm? Dr. Wolf started to answer, well, I know that there was cutting too, and I emphasize cutting, and then he was cut off by Attorney Brennan, and Attorney Brennan said, may I approach and receive the exhibit, Your Honor? And we note that in the context of many other statements in this regard as to what happened. So now this comes to the requested relief, and I'm going to move to the part of the argument, Your Honor, that we believe respectfully compels what we're requesting. So now I want to just state what we request. We believe it's what we've requested is quite modest given what happened. And our proposed curative instruction is on page 2 of our motion. It states, during the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt, Exhibit 88, falsely insinuating that those holes were sustained on January 29, 2022 from a fall backwards. I instruct you that those holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the Massachusetts State Police, I've got the acronym MSP, Crime Lab, in the course of her inspection and sampling of the clothing on May 18, 2023. Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29, 2022. Please juxtapose that with regard to the instruction Your Honor had given, which was a sentence, so jurors, I instruct you that those holes were made by the criminalist, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt.
Didn't I include the date you requested, the May 18th date? I thought I did. You know, Your Honor, I think the answer is no, but because I'm doing it from memory and I don't.
This is not an official transcript, right?
Exactly, Your Honor. So I can't say it with certainty. I don't believe it was.
Okay, because that date you told me was important to you, right?
Among other factors, the date was important.
It's May 18th, right?
Yes, Your Honor.
Okay. Go ahead.
And so, Your Honor, I believe what is fair in the analysis and as objective as I can be here is, I think the curative instruction has to tether to and relate to in its details the degree of what happened. This was on a very significant topic, accident reconstruction, a significant piece of evidence, the hoodie. There's been much discussion among many expert witnesses about this hoodie, what it stands for. There's been videos on it. You know, our position, the hoodie in a proper accident reconstruction would be completely unaffected by any alleged motor vehicle incident. And then to show the witness on this for the defense, it clearly left the impression to any objective observer that Dr. Wolf had somehow been incompetent, which is 180 degrees of the reality, but also that he just wasn't otherwise diligent, and the jury therefore should not weigh and value his opinion. This is very, very significant. And I underscore, Your Honor, we didn't cause this problem. We didn't cause any of this issue. So to me, I do not understand why the Commonwealth would not support this. What we have written down here supports the truth. We all, I believe, should have the common goal of the jury receiving the truth. I looked at the jury. I'm no soothsayer or mind reader, but I looked at the jury and they looked confused when I looked over at them. But I think even aside from looking at a jury, what Your Honor did in good faith, I don't believe is clear enough on this key issue. And I'm not understanding why there would be any real contest over making it clear to the jury on this very important point. The defense, to my point of being measured at the time and being measured now, we could be requesting a lot more statements about what occurred. And I've been in situations in other trials where things have happened and there's been many more significant things stated. So in conclusion, Your Honor, the defense not having contributed at all to this issue, the significance of the issue, the significance of the error, it's undisputed about the error. To me, respectfully, all augurs for more clarity here. And the final point, there's two issues here. There's the fact of when these holes occurred, these cuts, and how they occurred. That's one bucket. But the second bucket, which is not in the current instruction, is our expert witness, Dr. Wolf, and the impression left upon him. And that is why we have the language in there. Again, we believe quite measured, just the sentence at the end to take care of the harm to our witness with regard to what occurred. So therefore, Your Honor, we respectfully request that this be given so that the jury has a clear and complete and truthful understanding of not only what happened, but also to make sure that it is what's created for the jury is accuracy, hence truth can be concluded. Thank you, Your Honor.
Thank you. I do just want to point out one thing. It was not objected to at the time it came in. That's my only comment. I will consider this. I'm going to hear from Mr. Lally. I will consider this.
What is it that was not objected?
The testimony was not objected to. I didn't hear this until I think after another witness.
Your Honor, if I could just thank you for raising that. 10 seconds for that. I will, and I made this point the very time that I made the argument last time. We were not shown that Exhibit 88 in the encasement. It was behind the witness. We didn't even know that it was behind the witness. So what happened was Attorney Brennan went up, retrieved it, and immediately went to the witness with it, showed it. We couldn't even see what was happening. There was no physical nor other ability for us to object at the time. So I appreciate you giving me the opportunity to respond to that.
All right, Mr. Lally. Keep your voice up, please.
Yes, very briefly. I'm not going to get into a belabor the point as far as the back and forth about conduct of counsel. During the heat of trial, during the heat of the extended exchange with a witness on the stand, things can happen. Mistakes can be recognized, acknowledged, and accepted as a mistake. There were numerous offers by the Commonwealth to offer a stipulation as to the truth as far as the evidence is concerned that were rejected by the defense. They wanted the curative instruction. They got it contemporaneous with when the evidence came in. There have been many instances of similar type conduct that didn't result in a curative instruction, and to accentuate it further in the final charge to the jury is simply improper. It was a situation that arose as far as whatever misstatement was made at the time, as far as whether it's from the testimony from the witness or the question from counsel, was immediately remedied, was taken care of. I don't think that there's any confusion by the jury. And furthermore, as I indicated, the Commonwealth offered a stipulation at the time that this occurred, which was essentially rejected by the defense. They got the curative instruction at the time. That is all that is required. It is more than sufficient, and it doesn't need to be accentuated or addressed further in the final charge.
Okay. So I'll consider it, Mr. Alessi. Okay?
Thank you, Your Honor.
All right. Anything else? Two things I'd like to talk about for scheduling. The jurors get here early. I'm going to ask if the court officers to call the jurors and ask them two things. To ask them if they can get here a little bit earlier so that we can all be in the courtroom at 8:45, ready to start. So things take a little while generally. That will assure us the closing arguments will start right at 9, maybe a few minutes earlier. The goal would be to hear arguments from both counsel and then take an early lunch break. I would ask that counsel plan on just a half an hour lunch break. I'd like, the point being, I want the jurors to start deliberating. I don't want to end the charge and send them home for the weekend. That's not fair after they've waited so long. So a short lunch, you're free to stay in the building and court officers will help you with accommodations for that. But a short lunch, and then I'll come out and do the charge. And then at least hopefully there'll be some time for them to deliberate. I'm going to ask the court officers to call the jurors to see if they can stay as late as 5 o'clock or 5:30 tomorrow night. I just don't think it's fair after they've sat through so much of this trial with the various delays that we've had to not let them start deliberating.
We have no objection to that. One request we have, Judge, is during the last trial, during deliberations, the court had asked us to be within 5 minutes of the courthouse. My office is about 10 minutes away.
I'm sure we can make accommodations for that. But at some point, we may have to talk about security issues. So a lot may depend on that.
Understood.
All right. Does the Commonwealth have any objection to that schedule?
No, Your Honor, not at all.
All right. So we'll see counsel in here no later than 8:30 tomorrow morning.
Sure.
We'll counsel here at 8:30. All right. Thank you.
All rise for the court, please.
I get it.
Is there already one of these, like, are we swapping?
Yes.
Goodbye.
Thank you.